Hey folks, this is Karen Trepte of Gaijin Works Coaching, your productivity coach. I am so thrilled and honored today. You're going to love her. Autumn Boyd is with us. She is a lawyer, so we honor her time as we honor everybody's time. And we're just going to jump right in. So, Autumn, do you want to give us a little brief intro about you before we start asking you some tough questions?
Sure. Hi, Karen. Thank you so much for having me on today. I'm excited to chat with you. Like you said, I'm a lawyer. I've been a lawyer for about 12 years, and I've kind of weaved my way through lots of different jobs. I worked for a judge. I worked for a big law firm. I worked for a small law firm. I've done all kinds of different things, but I went out on my own and started my own law practice a little less than 2 years ago. So since then, I focus my practice. I do a lot of copyright and trademark work, and I really love working with creative business owners. So bloggers, podcasters, online business owners, coaches, graphic designers, photographers, all kinds of creative people. So it's really fun. I love what I do now.
Perfect. We always love to find people who love what they're doing. So let's talk about copywriting. Now we have a varied audience. So some of us are just barely starting out, and there are also some folks on here who've been in business for a few years. So if we could really address those couple different levels as we go through our little virtual tea chat here, that would be great. So let's talk about the copywriting then.
Yeah. So everything I say, just as a little disclaimer, I'm licensed in Tennessee. But most of what we'll be talking about today is going to be federal laws. So it's the same in all 50 states. But I don't do anything internationally. So if you have any international listeners.
We do. I'm an international business coach. I work in the Middle East. So yes, go ahead.
Yeah. So many of us in the online world, there are a lot of things that cross borders, but unfortunately law is not one of them.
Okay.
Everything I talk about today will be under U.S. law. So copyright laws in the U.S., once you create something, you get automatic protection. It's really nice in the United States. It's very friendly to creative people. You have to do what they call fix in a tangible form. So that could mean typing into your computer or recording it with your voice. It just has to be, it can't just be in your brain. You have to spit it out somehow. And then it is automatically protected by our copyright laws. Now the caveat to that is it's a limited protection, and you get better protection if you do actually register your work with the Copyright Office. So if someone steals your work and you want to sue them, it has to be registered.
Okay, so I'm just going to use, because if I was in a tea chat with you in the tea shop, I'd ask you this way. I have a Feng Shui time management online course that I've developed. I have not copyrighted it, anything like that, but it's definitely in a format. I mean, we're already selling copies of that. So I guess advantages, disadvantages of registering it.
Yeah. So since you created it, you are the author and the owner.
Okay.
Of everything that you actually created. So like if you're quoting other people or if you're using images or things that don't belong to you, you wouldn't own that piece of it, but you would own everything that you've created.
Okay.
And that's true for like the text or the photos. Copyright does not protect ideas. So you can't like keep somebody else from creating their own Feng Shui course. But the way that you have expressed that idea, so your actual words and, the outline that you've created or the way that you've done videos or whatever other content you have, that is automatically protected. If you are making money off of that course and you want to keep other people from copying it and you want to be able to stop them if they do copy it, then that would be the point that you'd want to think about registering the copyright. The two benefits of registering the copyright is one, you can sue people. You absolutely cannot sue people for copyright infringement if it's not registered. And then the other is if you have to sue someone, God forbid, your damages go way up if it's registered early. So that's kind of the Copyright Office's, it's a carrot to kind of incentivize people to register their works. They give you some advantages. So you go from being able to get what they call actual damages. So that's like if someone had come to you and asked permission to use your stuff, what would you have charged them? And then you can also get whatever profits they made. Usually that number is pretty small for something like this. Maybe it's a couple $1,000s. So if you registered it before they copied it, that number goes up to $150,000 is your ceiling. So that's a nice incentive. And then you can also get your attorney's fees. So the other side has to pay for your attorney who actually brought the lawsuit. Okay. So it makes it a little more, it gives you an incentive to go after people because it, makes a little more monetary sense to do that. If all you can get is a couple $1,000s, it's not usually worth filing a lawsuit at that point. Absolutely.
So this is actually great. And I'm going to just keep using my example because it'll get into details. And I'm sure there's lots of other of us out here who have their own courses. I mean, you've said so many fascinating things to me already. Like one of my questions I didn't ask you was, well, I'm a productivity coach. I mean, I've been reading productivity books for, I don't know, I guess everybody knows how old I am anyway, but for probably 40 years, maybe a little bit more. So I know that a lot, and plus productivity, I mean, a lot of those ideas are just, yes, I've used them. I've done Franklin Covey. I've done all of that. And I certainly attribute whenever I can figure out how to attribute, like Stephen Covey or Fly Lady with the 15 minutes or whatever. And I'm going to jump around because that's how
okay.
Anyway. So sticking to that, like, how would we, because I've been concerned about that before, and actually I've just, after having written tons of content myself, have just started like reading newer books and so on. And a lot of times I find that, oh my gosh, one of the concepts I've already taught is like a whole book that somebody else has published. So what are the boundaries around all that? So confusing.
Yeah, it's tricky. It's definitely a tricky area. I mean, the thing to keep in mind, there are probably no new ideas. If you read Shakespeare, all the stories to be told have already been told.
Okay.
But what you can protect is your particular way of telling that story, your spin on it, the way you teach things. So certainly, and this may cross into trademark law a little bit, which is that protects things that are like identify a business. So a product name or a slogan or a catchphrase, those can all be protected by trademark law. So some of these things like Stephen Covey, I'm sure some of the things that he teaches are protected by trademarks.
Like sharpen the saw or something.
Exactly.
Okay.
Yeah. And so you obviously need to be careful with those. And those are pretty easy to search for. You can go on the U.S. Patent and Trademark Office website. There's a free search engine that you can see if something is a registered trademark. And so you should definitely avoid using any registered trademarks in your work unless you get permission. And sometimes these people, even if they're really big deal, will give you permission. It just depends. Everybody's different. But for the copyright piece, as long as you're using your own words and you're creating it from your own brain, that's going to be the best bet. If you are taking somebody else's stuff and trying to kind of twist it into your own thing, it's a really gray area. And there is a lot of people will ask me about fair use, and that may be a concept that you've heard about.
I don't know what that means. What does that mean?
Yeah, so fair use under the Copyright Act, it's actually in the copyright law. It is basically a defense if you are sued because you use somebody else's stuff. So first thing to know is it will not keep you from being sued. It's a defense if you are sued. Okay. Then there are certain circumstances where you're allowed to use other people's stuff and it's not considered copyright infringement. And those are mostly things like commentary or parody, where to make your point, you kind of have to use a little bit of the original source material. News reporting is also sometimes you're allowed to use a little bit to do news reporting. Most creative people who say, well, if I change 10%, then is that fair use? That is probably not going to be fair use. Fair use is, it's very, very gray. And I always tell people, if you're willing to be sued and then have to let a judge decide whether he thinks it's fair use, if you're willing to base your whole business model on that, then okay, you can rely on it. But that is a pretty darn big risk, if you ask me, in something it's really subjective. And if you do get sued and you use it as a defense, the court will look at a couple factors, like how much of the original thing did you take? Are you making money off of it, or was it a nonprofit use? Are you displacing the market for the original? So are you basically selling it to the same people who would have bought the original thing? And usually when you look at it that way, it becomes clear that most things, unless they really are true, like commentary or parody, most things are not going to be fair use in the e-course world or what we've talked about.
But the education that I've had over the years through my MBA and all of that, I mean, it's all just kind of mushed together in my brain at this point.
Right.
With, the books I've read, so I don't even know, other than like those two sources I quoted you, like.
Right. Well, I would say, I mean, unless you're sitting down with, your Franklin Covey book to the side and you're looking at a sentence and saying, oh, how can I rewrite that into my own words? Right. That is. But if it's just, all the ideas that are mingled in your head, I mean, I think you see that with music, you see it in lots of places that, that happens to all of us.
Okay.
Yeah.
Okay.
Yeah.
And then another question I have, I've done some of my own copywriting. I've also employed some other people to help me with copywriting.
And that's copywriting with a WR, correct? Or are you talking about registering your copyrights?
No. I mean, just WR, yes.
Yeah.
So just hiring, different copywriters to help me with different things along my path. And then some of it I've written myself. So how does that, I mean, what if a copywriter then came back later on and said, oh, I wrote that. She didn't write that.
Yeah. So you should absolutely be getting an agreement in writing with your copywriters. Because under U.S. law, the person who creates something is automatically the owner. And that is true even if they're doing it under contract for someone else.
Even if they're paid for it.
Yeah. So if they're actually your employee, like a full-time employee, then you own it because you're the employer.
Okay.
But if they're not a true employee, then you have to have an agreement with them in writing. And that is what people may have heard. It's called a work for hire or a work made for hire. But it has to be in writing. So you can't just, even if you've hired somebody to do a project for you and you've paid them, it still belongs to them unless they give you those rights in writing, or in writing you agree that it's a work for hire.
Interesting.
So a lot of people don't know that. Yeah.
Don't know that. I'm like, I've paid all this money. Like,
yeah. Well, and I've had it come up too where I've been doing registrations for people, and I've said, who actually created it, and they'd say, oh, like you said, the copywriter did, or I hired this guy who created my logo. And so I've said, well, do you have an agreement that says it's a work for hire? No. And so I've said, I can't register it until you go get the rights from that person. And usually they're happy to do it. It's just something people don't know to include in their contract agreements.
Right. Okay, so much.
Yeah, you definitely want to own. You definitely want to own the things that are valuable to your business, for sure.
So, for someone just kind of coming up in the entrepreneurial world, can you give us some idea, please, of prices? So, if somebody's on the edge and thinking, "Oh, should I register this or not?" How much would it cost them?
Yeah, so the Copyright Office website will allow you to do all the registration online. And it's fairly easy. The system is kind of outdated, but it's $35 to $55, depending on kind of some factors in the registration. So if you have a business and you're registering, or the business is going to own it, it's going to be that $55. If you're an individual, it's going to be $35. If it's a work made for hire, it's going to be $55. If it's a collection, it's $55. So for most things, it's going to be that $55 mark. But that's fairly inexpensive. And you can register, for your course, you can bundle that all together. So if you have videos or PDFs or worksheets, you can kind of, as long as you're selling it as one piece.
Right, I am.
Yeah, then you can register it all together. The trick comes if you have somebody who has made a a collection of things, but they're selling them as individual pieces, you would have to register each piece separately, which can get expensive. You know, if you're then talking about lots of pieces, it can get expensive. Yeah, even though the single registration fee is fairly low. And there are some tricks, like for photographers, there are some ways you can register big groups of photos. They've kind of got a special procedure for that. And the Copyright Office has tons of great information on their website if people are looking for more information. Lots of free guides and things that they'll give you some guidance. But yeah, and the nice thing about copyright law too is that it's written in such a way that is kind of generous towards copyright creators. So if you make a mistake, unless you were trying to defraud the Copyright Office, which most of us are not, they will kind of give you the benefit of the doubt. Trademark law is the exact opposite. It is much more difficult to register a trademark and much more expensive.
So I have a couple of sayings. Work is joy is one, and then I have simplicity, strategy, systems is another one. So is that considered like a trademark of my business? Yeah. Okay. So how would one go about doing that then?
Yeah. So in trademark law in the United States, there also is some automatic protection. It works a little bit differently than the copyright protection, but it's kind of a similar concept. So it's called common law trademark protection. And that is going to be, it's a little different in every state. It's a state law right. But just by using a phrase or a logo or something, you know, that identifies your business, just by using it in connection with your products or your services, you automatically have the trademark rights to that phrase or logo, as long as nobody was using it first. So we have what's called a race system in the United States. So it's the first person to use it wins.
Okay.
But it's limited to like the things that you're actually using it with. So let's say that you have a company called Magnolia, and you're using it to sell like face wash and beauty products. So if somebody else wants to start a company called Magnolia that is selling coffee mugs, you know, those are two totally different kinds of things. So that's fine, because trademark law, you're basically trying to always prevent your customers from being confused about two different companies. So you see that a lot, like with Delta. Delta is an airline, and Delta is also a line of plumbing fixtures.
Right.
So those are both trademarks, but they're in two totally different industries.
I see. Great.
Yeah. So that's kind of something to think about. And then trademarks also, these common law trademark rights that you get automatically are limited to the geographic area where you're actually using things. So in the online world, that's going to be everywhere, because we're kind of operating nationwide. But if you had a more local kind of business, then that would just be limited to where you're actually selling your stuff. So that's kind of your baseline first level of business for the people who are just starting. You do have those common law rights. And then when you're ready to, you know, if you've got a brand name or a product name that's really important to your business, and it would just really crush your business if somebody else started using it to sell similar products, then you should look at registering it, because that's going to give you that next level of protection. And you can register with the states. I don't usually recommend that, because most businesses, by the time they're ready to register, they're looking at a nationwide audience. So I usually recommend just going ahead and doing the federal registration at that point.
Similar price points with the 50? No. Okay. So
it's much more expensive. Yeah. So the minimum cost that you're going to pay just in filing fees is $225. And that is for trademarks. You register with the types of goods or services that you're providing. So it's that same concept that you only get protection with the things you're actually selling.
Right.
So they have what are called classes. So that's like a group of products or services, and you pay that filing fee for each class. So like if you wanted to sell t-shirts, that's one class, coffee mugs, one class, educational services, that's a class. So it's really easy to rack up some pretty big filing fees pretty quickly.
Yikes.
And then for trademarks, for copyrights, it would be great if everyone had an attorney, but realistically, you know, not everyone can afford an attorney, and the law is really generous. For trademarks, it really is helpful to have an attorney. It's a complicated process, and the trademark office actually has attorneys that review every application and look for mistakes, and look for reasons basically to deny an application. So it's really helpful to have an attorney handling that process for you, because lots of applications, they get what's called an office action from the trademark office, which is basically them just saying, hey, you made a mistake, or hey, we don't think this is correct, or you need to change this. And for a creative business owner, most people get those. They're like, I don't know what to do. This doesn't make any sense. It's full of legalese and jargon. And so most people just at that point, they abandon the application, and they've spent all that money on filing fees and they have nothing to show for it.
Right.
So I will often recommend that people wait until they're at the point in their business where they can afford an attorney to actually do it the right way, because you can spend all that money on filing fees too, and if you word things the wrong way, then it's not going to end up protecting you like you need it to. And if you have to enforce your trademark rights, you end up with something that doesn't really do what you needed it to. So it just is kind of a waste.
One of the things that I was going to ask you too, because I'm willing to bet that there's other people besides me who probably wouldn't even do any of this without an attorney. So when we're thinking about when is it reasonable for us to do it, like, is that okay to talk about the money? I mean, how much does it charge to say hire you to do these different things?
Yeah, so like for a trademark, and I personally charge mostly flat rates. A lot of attorneys will charge hourly. But I just like the upfront pricing. I like everybody to kind of know what they're getting into from the front end. And I do enough of these things over and over that I kind of know how long it takes. So, I can feel confident charging a price where I feel good about it. So I charge $900 is my flat rate to file a trademark application. And that doesn't include the filing fees, because those can really vary depending on what somebody's doing. Since the copyright registration process is simpler, I just charge $350 for that. It's a shorter process. With the trademark application, I include helping you respond to those office actions, as long as they're a simple office action. There are some office actions that you get that require basically almost filing a legal brief that requires just hours and hours and hours of work. So I can't include that because it's such a question mark. But yeah, and then I also do contract drafting. My prices for that start at $750. So, I think I'm fairly affordable for an attorney, but I realize that especially if you're just starting out, that is a big investment in your business. And I think people should think about it that way. It's kind of like purchasing a website or, making those big investments when you're at the point in your business when they make sense.
That's right. And then what about posting different policies? For example, for me, once I've done my coaching, that's non-refundable. So certainly bend over backwards to make people happy, but still the service has been rendered.
Right.
So what types of things should I be putting on there? Is just simple language on my website enough, or what does it need to be?
Yeah. So do you use a contract with your coaching clients?
With my larger ones, I can, but most of the smaller ones, I don't.
Okay. If it's just kind of a one shot or.
Right.
Yeah. So what I recommend for that is that you have, you can have it on your website, but you need to have whatever your policies are, and then you need to have a way that they agree to them before they pay you. Because basically it is a contract, whether you call it a contract or not, where you're providing services and they're paying you for them. So you're exchanging money for things. And then you have the way that you do business. You have your policies for cancellation, or you have, like you said, that you don't refund money after the fact if they're unhappy.
Right.
So what I recommend is, you can have them on the payment page if you can have them there, or you can have a link where they can go look at them. But you need to have something on your website where it says like, I agree that I have read these terms and conditions, and, I agree to abide by them. And then you can either have like a checkbox or somewhere where they put their initials in or something like that. But it's basically, think about if you had to sue someone, what would you want to show the judge to prove that they did actually agree to these policies? Because otherwise it's just, nobody really knows what they're agreeing to, and it's all very loosey-goosey. So that is going to give you the best protection.
Thank you. So basically it really should be written, even if it's...
Even it can be really simple. It doesn't have to be like this legal jargon.
Okay, because I have for new clients, I charge them only $97.
Yeah.
Plus, they get, an action sheet. They get a worksheet in the beginning, and so
Yeah. You can't refund them.
So I don't make them like sign a contract to check
Right.
or anything like that. But I should put something on my little payment thing, is what you're saying.
Yeah, and you should also be, if you're not thinking about this, and I say I'm a copyright evangelist. I think everybody should be protecting their stuff. But you should also have something that says like that you own the rights to all those worksheets and that they can't copy them unless you're okay with them copying them. Some people are.
Right.
But if that were something really, that I had developed and put a lot of hard work into, I wouldn't want them, copying them and displaying them all over the internet. So just another something to think about.
That's awesome. That's awesome to really know. So if somebody's coming to you and has multiple copyright things that they want to copyright, is that $350 each, or how do you?
Yeah.
Yep.
And I do, for some of my clients, I will teach them how to do the registration themselves, especially if they're creating things.
Right,
and that's kind of a custom, if it takes me an hour of my time, then I just kind of charge for that to kind of walk them through and so that they can do it themselves. Especially somebody like a photographer or, somebody who's creating stuff where they need to be registering it pretty frequently.
Right. So what I know, we promised, I think I only booked like half an hour of your time. We're just about to the end of that. So 2 things. One, I want to know where people can find you.
Yeah.
So let's start with that.
Okay. My website is the best place. It's awbfirm.com. So like Autumn Witt Boyd. Okay. And there's tons of legal guides, free information, and I've got some videos and some webinars that I've recorded there. So lots of good stuff to kind of get you started. And I'm actually launching a podcast in November.
Wow, great. Okay.
Yeah, I'm really excited. So keep an eye out for that. It's going to be kind of almost like the content of a course. Mm-hmm. So it's going to take people through the first season, everything they need to know to kind of get their business set up legally, things to think about and steps that they should be putting in place.
Great. Are you charging for the podcast?
No, that's going to be, because I don't blog.
Okay.
That's going to be kind of my gift of free content to help people. And a lot of it, there's no easy answers like we've been talking about. A lot of it, it just kind of will get people thinking about what they need to do. It's not necessarily going to give them the answers, but at least I think it's helpful as a new business owner to know what you should be doing, whether it's now or in the future. And then you can kind of plan for that.
It's so completely helpful because really getting into, I've run multiple businesses in my life, but this is the first time I've done an online business. And so it's really quite a different animal, if you will, than doing the brick and mortar. So you've given us so much information. I do want to honor your time. Is there anything else you would like to say before we let this go?
Yeah, protect your content.
Okay.
For online business owners, that's often, it really is your most valuable asset. So registering your copyrights and if nothing else, putting a copyright notice on the bottom of your website that just says, the C in the circle and the year and your name and all rights reserved to let people know that they can't steal your stuff.
Okay, that's great. So you can do that without actually even copywriting something. You can just
so in the US, since you get that automatic protection, you can absolutely use that C in a circle, whether it's registered or not.
Autumn, it's been so much fun meeting you, and I really
thanks for having me.
Your time. And so this is Karen Trepte, Gaijin Works Coaching, your productivity coach, and we will see you next time.